Good afternoon. My name is Thomas Bona. I'm a partner at Pillinger Tarallo, and I'd like to welcome you to our sixth Pillinger Tarallo St. John's Greenberg School of Risk Management Conference webinar series, and our second Pillinger Tarallo Claims Settlement Institute. When we began our St. John's Pillinger Tarallo Conference webinar series 4 years ago, our goal has been to provide ideas, thoughts, concepts, and strategies from industry experts and thought leaders that affect our industry. For those who are not familiar with Pillinger Tarallo, we are a regional insurance defense firm with offices in New York, New Jersey, Pennsylvania, and Connecticut. Our focus is very simple: results and value with swift, cost-effective resolution of cases. PMT has been in existence for 20 years, and over that time, we have resolved thousands of cases. And it's one of our things that we're well known for is our ability to resolve cases. So we thought that we would take our expertise and our knowledge in resolving cases and combine it with other like-minded individuals and create a vehicle where we could advance the art and science of resolving cases. And that is the Pillinger Tarallo Claims Settlement Institute. We have a great webinar today, Secrets of Successful Mediation, and we have a terrific panel that's going to give you ideas and concepts that will help improve and make mediations more successful and better. Before we start, I'd like to first thank Dean Norianne Sharp from the St. John's Tobin College of Business for her help and her support. As I mentioned, our firm and myself have deep ties to St. John's, and so we're very happy to be working together. I'd like to thank Dean Brandon Switzer from the Greenberg School of Risk Management for his help. And I'd like to thank Larry Pastel from the Center of Executive Education, and Joe Levine and Rob Stewart from CC&G, PMT's branding and marketing partner, for their help in putting our program together. Today's program is about secrets of successful mediation, or what your attorney never told you. And we know that mediation, like every process, they're secrets that will help make the mediations more successful and more effective. And so we have gotten a panel of industry experts here, people who are well known for their ability to resolve cases and have resolved thousands of cases. And so I'd like to start by asking our panel to introduce themselves and just tell us a little bit about themselves. Anthony Coleman, can you start us off, please?
Absolutely, Tom. Good morning, everyone. Excuse me, good afternoon, everyone. My name is Anthony Coleman. I'm a VP in claims. I've been in the insurance industry for 25 years, and I've mediated cases across the country and seen it from different perspectives from Maine to California.
And Jeff Miller, can you please tell us a little bit about yourself?
Thanks, Tom. Jeff Miller. I'm one of the founding members of Pillinger Tarallo, and thrilled to be here today. And thanks to St. John's for allowing us to partner with you to do this presentation.
Marc, can you please give us a little bit of information about yourself?
Yeah, my name is Marc Pillinger. I'm also one of the founding partners of Pillinger Tarallo. Jeff and I have lectured to the Office of Court Administration on mediating cases for the court mediators. So this is a very important, timely topic.
And finally, John Tambascia, could you please tell us a little bit about your background, please?
Yes, partner at Pillinger Miller. I have been handling complex cases from legal malpractice to construction to trucking for the past 25 plus years. And I try to bring a real world perspective as well as a technical perspective to cases, because one of the biggest problems is bringing people together when you're trying to mediate. And that's what I'm going to be talking about.
That's terrific. Now, let me just mention at the outset here that we'll be having some polling questions so that people can get CE and CLE credits. And also, I want to encourage people that if you have questions, please get them up to us and we'll make sure that we get them answered. So let's dig in. So we've got a great topic today, which is secrets of successful mediation, or what your attorney never told you. And mediation, like Marc mentioned, is something that everybody is talking about. Plaintiffs, defendants, insurance companies, mediators, judges, neutrals. Everybody wants mediation. So let me start off by asking Anthony Coleman. Anthony is the Senior Vice President of Tradesman Programs in MGA. He's been on the inside of insurance companies for years before that. And he has a wealth and a breadth of experience with all kinds of cases, but especially with complicated cases, with high value cases where the stakes are very, very high. And so, Anthony, let me ask you this. Insurance companies love mediation, correct? I mean, what's not to like from your perspective?
No, obviously insurance companies do love mediations, but there are things about mediations that they don't like as well. Just to kind of start with the love side of mediations. I mean, the primary reason companies love mediations is because you can save costs for not only defense, you can save costs for experts, and obviously the company can protect itself from any runaway verdicts that you could have. So that's the primary main reason that companies like mediations. Another reason is mediation days. Mediation days can be very beneficial to an insurance company because if you have a bad account, where you have a lot of adverse claims on, or if you have a runoff book that you're dealing with, or if there's an attorney, a plaintiff attorney that you have a lot of claims with, this is an opportunity to take a day and take a bulk of cases and be able to resolve those cases, because the last thing an insurance company wants is to have these liabilities hanging around when there's opportunity to kind of move them along. Another good thing about a mediation is that, everybody has some biases. So if you have a good mediator, he can also help you with your evaluation of the case, things that, you may want to pay more focus on, or things that you really didn't think about. A good mediator can kind of help you with those things, which can, give you a more developed analysis of your case. And also another reason we like mediations, because even if you can't resolve a case, at least the plaintiff attorney, co-defendants get to turn over their hands to a certain extent. So you'll get to see, what the other side is planning. So you have a better idea of what to anticipate, should that case proceed and end up going to trial. So you get a quick peek behind the curtain. Then the other reason we like mediators is, if you're able to build good relationships with mediators, a lot of times, even if you exhaust your 3 or 4 hours with a mediator, will take the time to follow up on the phone, secure documents from parties and kind of keep that conversation going and keep the ability to resolve that case alive. Which is certainly helpful. So it doesn't necessarily end after that 3 or 4 hours of mediation. And a good mediator also helps you with scheduling. Sometimes it's difficult for parties to get together. So, I've had mediations, especially with Jeff, where we started in the morning, some sunrise mediations as early as 7 a.m. Some mediators are willing to do it on the weekends. So, those are the primary reasons, companies like to have mediation. But it's not always love with mediations. There's certainly reasons that insurance companies are hesitant about them as well. One of those reasons being that sometimes you have mediators that don't listen to all your arguments. You have a case, they're like, oh, it's just $240, it's a fusion, you have to pay. But sometimes you have nuanced arguments about causation and different things that you want to bring to the forefront. And sometimes mediators don't pay enough attention to some of those nuanced arguments. So you have to be careful with that. Another issue is sometimes you have a mediation and you'll run out of time, but the mediator try to keep you around, but he starts another mediation. The problem with the mediator doing 2 mediations at the same time is that, they lose effectiveness. You lose his attention to a certain extent. So sometimes, you lose the value that you have with that mediator when he has to split his time with another case. Also some of the better mediators are hard to book. You find the good ones that you like, that you find to be very effective. and you have a case that you're looking to resolve, and he's pushing you 3, 4, 5 months down the road to resolve a case. I mean, that's certainly not helpful when you're trying to move a case along. Another reason not to be fond of mediations is that sometimes you find plaintiff attorneys who are not responsive, who are not prepared. Sometimes plaintiff attorneys don't understand the liability arguments. Sometimes they haven't really versed their clients about the true value of the case. And those things become impediments when you're trying to move a case to a resolution. Additionally, when you have a multi-party case and you have co-defendants, sometimes when you have a co-defendant who's obstinate, a co-defendant who kind of comes there and doesn't really want to actively participate in that mediation, it stalls the mediation, especially when you're expecting a meaningful contribution from a co-defendant. So that's another obstacle. And then the last thing I wanted to mention as a con to mediations is that when you go to mediation and the coverage hasn't been ironed out, that can also be an obstacle as well. So if you arrive at the mediation and you got parties that are bickering about their defense fees haven't been paid, they're bickering about they should be indemnified, and this guy should be paying the money. It just breaks down your mediation. Your mediation is unable to go forward. And really with the last 2 points, a lot of times it's beneficial, just to have a coverage only mediation, kind of iron those points out preemptively. And sometimes, if it's protracted enough, perhaps even a defendant's mediation only, that can kind of help you iron out those nuanced points before you invite the plaintiff in. So those are the kind of the pros and cons from the insurance company's point of view for mediation. Thanks, Tom.
So Anthony, so I guess it's kind of like when you put the whole package together, let's say this, it's kind of like having candy or having ice cream. It's great, but sometimes can you get too much of it? Is there too much mediation? Is it just like overkill with it because some of them are just not going to be productive?
I mean, that could certainly happen. I mean, there's always a time and place for everything. So I think, once you've gathered enough of the facts and you understand the liability picture and the damages picture, mediation makes sense because, again, I mean, when you start heading towards trial and you're wasting money on defense and experts, you certainly don't want to do those things if you have a case that's able to be resolved. But, to your point, you don't want to preemptively run the mediation, especially when you haven't ironed out the issues. Then the mediation doesn't become productive at all when you haven't had a chance to kind of iron out really where you are on liability, where you're at on damages, and where you're at on coverage. But once you kind of put the coverage, liability, and damages ducks in a row, I think mediation is certainly the way to go. It's the most cost-effective way to go.
Thank you, Anthony. Now let me ask you one question here, because Marc and Jeff will be talking about this because they have been involved in this. But New York state courts are going to be requiring cases to be mediated early on in the proceedings as a way of trying to weed out those cases and trying to move cases that are susceptible to resolution. And it's part of their strategy called mediate first, as opposed to trying to do discovery and get things, into the litigation mode mano a mano. Do you feel that from your perspective, being in the claims arena as you have been and as you are now, is that necessarily going to be productive, maybe productive, somewhat productive? Maybe it's too soon. Maybe there's not enough information to be able to have something legitimate to move forward with. What are your thoughts on that, Anthony?
I'll say this. I mean, I'm not too versed in prospectively what the courts want to do, but historically, all the New York courts have had a mediation part. The problem with the mediation part is they don't dedicate enough time to the case. So unless that case is able to be resolved in probably a 20-minute conversation, it's probably not going to be resolved. So, however the plan is that they need to develop a mechanism where they give the case enough time to resolve, because that was always the issue when going to a mediation in Bronx County, New York County, or whatever, is that they would give you a hot 15 minutes to resolve the case, and that just really wasn't enough to get to the nuance of the case. So presuming they can present a vehicle that gives you the necessary time to kind of understand the nuances of the case, then yes, I think that potentially could be productive.
You feel that maybe at least getting people to start talking, even if you can't get a resolution, is maybe a beneficial thing? Because as you say, how much time can the courts devote to a mediation? Half hour, certainly probably not more than that, given the dockets and how many cases are still hanging out from, the COVID period.
Absolutely. And
least,
that ends up being your problem. It's like, especially when you start talking about the more complex cases, you have all these arguments when you start doing a deep dive on liability, a deep dive on damages, and you're talking causation, and you have all these other issues that you're trying to iron out. A 15 to a 30-minute conversation is probably not going to carry the day and lead to any type of meaningful discussions in terms of getting to a resolution.
Would it be more helpful to say maybe that's a better vehicle for maybe your simpler cases, your auto cases, your premises cases, and maybe set aside something more particular for the more complicated cases like you have been involved in, and Mark and Jeff and John have been involved in, that sometimes can take maybe several sessions of mediation or several hours to get parties to really come to grips?
I mean, potentially. I mean, if you have a fairly straightforward case, your auto, your rear end hit where things are fairly clear cut, but potentially yes. I would certainly say potentially yes. If you have a fairly straightforward liability case and you have a simple injury, if someone has a broken arm that was casted, there's not too much nuance to that. And they were in a rear end accident, there's not much to argue about that. Potentially, for those cases, if you can kind of pair out those cases, maybe, then maybe, yes, I would certainly say there's a possibility that 30-minute conversation could lead to resolution.
Okay, Anthony, we have a question, so I'm going to throw the question out, and we can have Jeff and Mark and you and also John answer the question. The question is, how often do you see plaintiff counsel assigning a different plaintiff attorney to attend the mediation? I run into this several times. The stand-in plaintiff attorney does not know the case, damages and liability, which can then be a frustration and a potential waste of time.
Yeah, I'd love to kick off on that one.
Jeff, please.
There are times that you're showing up at a mediation and it's Block and O'Toole, and you know who you're getting. And if they're showing up at that mediation, they're going to be ready with the right attorney and the right authority. But I can't tell you, and I got to look who asked that question, how frustrating it is, Justin, when we mediate, and I don't want to trash any other firm, so I'm not going to throw names, but we have a program that we mediate quarterly on, and it's a grocery program, trip and falls in grocery stores. And the same counsel every quarter that we do this, because they have a lot of cases, they're a big volume firm. I speak to the main partners. First name might be Marc. Well, I'm going to leave it at that. And, or Ira. And I say to them, guys, we're going to be mediating cases. Come on, get ready. And they're like, oh, no, we'll be there. We'll be there. And the morning of the mediation, I get some kid in a t-shirt who doesn't even know the file name, let alone anything about the file. And it is unbelievably frustrating. And I agree with you. The main bigger players are always ready. I think some of the higher volume bottom dwellers, and I agree with you, it becomes a waste of time. It just becomes a waste of time. But we always try to check in with plaintiff's counsel and confirm that somebody with authority and with knowledge is going to be there. But you're absolutely right, Justin, incredibly frustrating.
Jeff, that's a great answer. So let me go right to you for our next segment. Secrets of plaintiffs for successful mediation. You've been involved in thousands of mediations. You're well known in the industry for your ability to resolve cases and resolve very, very tough cases. And as Mark has mentioned, the Office of Court Administration has asked you and Marc to teach attorneys how to mediate cases, because it's not something that you can just step up and say, I'm going to mediate. There is an art, there is a science, and as you know, some people can do it and some people can't. So from your perspective, could you tell us what some of the secrets of plaintiffs for successful mediation that you have seen over your years of mediating cases?
Absolutely. Thanks, Tom. And Anthony, really nice job. Really nice job from the carrier perspective. The pros and the cons. We're all in the resolution business. That's what we do for a living. We resolve cases. And we know that 98, 99% of these cases resolve through settlements, not through trials. You got to prepare as if it's going to trial, and you got to be ready. But the quicker you start the high-low game, the quicker you start negotiating, the quicker you start talking about resolution of the case, the quicker it's going to close. I have to say, as much as I'm giving these secrets of plaintiffs for a successful mediation, I'm not a plaintiff. I'm just playing one today. And that's why all the other gentlemen on the phone have their ties on. I don't have a tie today because I'm a plaintiff. For those of you used to mediating with some of those plaintiffs, a lot of them don't like to wear their ties to their mediations. But it's all about preparation. It's preparation. If you think about, and sorry for the football analogy, look at Peyton Manning or Tom Brady. You know why they're successful, besides being phenomenal athletes and having great teams and great coaches? These guys were preparers. They always prepared. You've heard articles about Peyton Manning, a Sunday after a game, would immediately be having the tapes of his opposing teams for next week in preparation of. So a position paper is a must. It's your opportunity to speak to a mediator, give the mediator your position before you get in the room. So those Block and O'Tools, the Gare Connaissance, they come in ready for mediation. They're prepared. And I will say PMT goes in prepared. It's important. They'll have their exhibits and they'll be ready to discuss the medicine firsthand. And they have the knowledge to move these cases. So with that said, here's some of the things that we found that plaintiffs have used in mediating these cases that the plaintiff bar believes from their side is useful. We all know that insurance carriers crave settlements. Carriers and clients are always looking to resolve cases. We're looking for low-hanging fruit. They want to settle cases before defense costs pile up. We always speak about, to our younger, newer attorneys, it's the best combination of defense and indemnity dollars to resolve the case. And we spoke about settling early. There's no such thing as too early. As long as you have proofs and you can analyze the liability, you could put a price on a case. There are carriers that want an initial report with an evaluation within 30 days. And everybody's like, we don't have enough. I was like, we have enough to value the case based upon what we have at this time. And we do. So, it's the best combo of your defense and indemnity dollars. It's not great for defense counsel to sit there and go through a case all through discovery, depositions, IMEs, post-note of issue, and rack up $30,000, $40,000 in defense costs and then close it at $20,000. You should be able to close that case earlier on. So the plaintiffs know that the carriers and defense side are looking for resolution and before the costs pile up. So let's all keep that in mind. The second thing, there's not a chance the cavalry is coming. The cavalry is not coming. Nobody's coming here to save us. Anthony mentioned it earlier with the timing that the court can provide you for a resolution of a case. We all remember the Mike McAllister days. You go in and you'd have 100 cards in the auto part and you get 5 minutes on each case. It's still, with the reduction, post-pandemic in judges and court personnel, there's long delays in court. and there's backups in court, and the judges just don't have the time to, and not a knock whatsoever on the judiciary, but they just don't have the time with their caseloads to spend 4 hours on mediating your case, unless it's a specific federal court case that they're going to give you a day to do something. So you gotta, nobody's there to save you. Which leads you into the third thing that plaintiffs know. Do it yourself. I got a list yesterday from Ken Halpern at Wingate Rosati. Ken Halpern sent me a list of 10 cases. I'm literally going to pull it up because he used such little snappy, sassy language. But he said, these are only going to get bigger and bigger. Let me know if you have any interest in resolving. And he listed about 8 cases. And I've now sent that to the handling attorneys within the office and said, hey, there's some cases that Wingate wants to sit down on. Let's get this on. But they're doing it themselves. If they want the case settled, they're pushing it because no one else is going to get that settled other than ourselves. So it's incumbent upon the plaintiffs, the defendants, and the carriers, and the brokers and clients, and the people on this phone, get it done. Do it yourself. The fourth thing, and plaintiffs know this as well, it's never too early or too late. I mentioned earlier in the talk here, it's never too early. We've settled cases pre-suit. We've settled construction cases pre-depositions. If you have the risk transfer worked out, you have the medicals to value the case, it's a case that you're ready to price. So it's never too early. And if you talk about too late, there's no such thing. We've all settled cases on the courthouse steps. We've all settled cases in jury selection. We've settled cases during trial. We settled cases when the jury is out. It's never too late. We're in the risk management business. You could manage your risk by settling the case. You could manage your risk while at trial and doing a high-low. But it can't be too early. It can't be too late. The carriers and the clients love dispositions. They're eager to resolve. They want it done quicker. Like our partner and MC for today, Tom Bona, says, and he happens to be a guy who makes his own wine. These cases are not like fine wine. They're not. They don't get better with age. So it's always time to settle the case. And the very last thing is, clients and the carriers love a closed case. There's nothing better than a closed case. The closed cases don't come back to bite you. You want to make a friend in the business, get a case settled. They'll thank you for it and they'll send you more. The best case is a closed case. You go on to the next. And the last thing I'm going to touch on is, listen in the mediation. Go in with an open mind. As much as it's a adversarial proceeding, you're there for the same thing. You're there to resolve a case. So listen to what they're saying, because there's things to be picked up during that that's very useful to all of us. And in closing, I'm going to mention March 16th, PMT is having our NCA luncheon. It's one of the best days of the year. It's an industry-wide event. Over 300 industry people, judges, risk managers, clients, carriers, brokers, plaintiffs' counsel, mediators. And it's 12 o'clock to 4 o'clock at the Killarney Rose, downtown Manhattan. Open bar, great food, and a good time to be had by all. So I hope anybody who's around can join us.
Thanks, Jeff. That was very incisive, and thank you for your input. And thanks for the shout out on the wine. Thanks for the shout out on our March 16th, which is a great event. And I would encourage all who contend to please come. We've got a question. Here's a question. In addition to having the correct plaintiff attorney present, and it piggybacks on the last question, is it fair to demand that plaintiffs show up to the mediation? They seem to appear less and less. Who would like to take that one?
Yeah, I'll take a quick shot at that. I would say at the very least, they have to be available by phone, because ultimately it's their decision on what number the claim resolves that, and it's incumbent upon the plaintiff attorney to make that presentation to him. It's nice for them to be there, but if they can't be there, they need to be accessible by phone or waiting by the phone for phone calls from their attorney.
Does it add something for them being there, Mark?
I find that it is a positive to have the plaintiffs themselves at the mediation, to see the process, perhaps to have the mediator communicate directly to the plaintiff if counsel's willing. Also, and I've been doing this a long time and I'm cynical, when a plaintiff is sitting at the mediation and hears that they can get $100,000, just making up a number, within 3 weeks, because you say, my carrier's here, we're ready to go, you can have your check. Plaintiffs themselves are more inclined to take the money than many times listen to their attorneys to wait for the extra 15 or 20. I like having them, I like having my adjuster there or participating. Obviously now we're talking, remotely. I want the adjuster to hear what the plaintiff counsel has to say, especially, the nature of the cases that I handle. They're big cases, they're labor law, they're environmental, they're complex litigation. I have great respect for my adversaries. And I have great respect for the mediators because we pick and choose. Both sides are very careful as to who we like to use. I find it kind of humorous that if a plaintiff walks away from a mediation unhappy, the mediator is pro-defendant. If the defendant walks away from the mediation unhappy, the same mediator is pro-plaintiff. I submit that the mediators who we choose based on our experience are neither pro-plaintiff nor pro-defendant. They are pro-resolution.
Excellent, Mark. Thank you. Let me ask the question, and then we'll get into secrets of defendants for successful mediation, Mark. But let me ask a question to Jeff and to John Tambascia. Do you find that having people present, is that like a reality check? Listen, the buck stops here. Listen to what the mediator is saying. You may think that there's no liability adjuster, but listen to what the mediator was saying. Does that kind of, all of a sudden give it a different kind of a shine to it?
Absolutely. The problem is you have two intransigent forces. One is the plaintiff, one is your client, the defendant. Remember, we have a lot of high retention SIRs, and they are of the opinion that they are right, always. Sometimes someone has to break the ice, and the mediator can do that in a nice neutral fashion. Plus, plaintiffs, unfortunately, they have disputes with their own attorneys. This is something we don't actually see. We know from experience it goes on. Necessary to be really the mediator's job at that role. I would get involved and say, all right, plaintiff's counsel, you're obviously having a problem. Let's deal with this separately. And that prevents the case from becoming a runaway train. So that's a critical factor. I think it's important.
Good. So we have a polling question we're going to take now because we want to make sure everybody gets CE credits. And these are tough questions, but we don't want to tax people. We just don't want to tax people. So we tried to make it, as easy on people's brains as it can. We're coming up on, the Super Bowl. We want to keep everybody sharp. Everybody a minute or two to answer that tough question. And I promise the next time we do it, we will write some different questions. We'll solicit some other questions which we've had in the past. So let me now go to Marc Pillinger. Marc, as I've mentioned, you're a founding partner of PMT. You've resolved literally thousands of questions. You've been involved in thousands of mediations. And New York State Office of Court Administration asked you to help train attorneys on how to mediate cases. So they acknowledge that you have an expertise which is valuable to the courts. So I'd like to ask you if you could tell us from your experience and what you've seen over the years, what are some of the secrets of defendants for successful mediation?
Thank you, Tom. A mediation is a coin. There are two, there's the heads and the tails, but at the end of the day, it's the same coin. And my approach to how hopefully having a successful mediation is personal interaction. Personal interaction with plaintiff's counsel, personal interaction with the co-defendants, third-party defendants. You're always going to have posturing and gamesmanship. That is to be expected. It is to be enjoyed. You don't get annoyed when the plaintiff's counsel maybe fudges a fact or two. You clarify their statements to the mediator. But as Jeff said, reach out to plaintiff's counsel early and often. The sooner you start the dance, the sooner you will be in a position to resolve the case. And not every case can be resolved. We know that. Preparation is key. Go to the mediation with your mediation submission and don't get it to the mediator 3 hours before the mediation. Have your exhibits lined up. Have jury verdicts available. If you have the smoking gun, depending on plaintiff's counsel, I believe in using it. So if you have a prior lawsuit where the bill of particulars alleges the exact same injuries as your case alleges, except it was a prior accident 2 years before, I'm a firm believer in playing that card at the mediation. I'm looking to get it done. Speak to your co-defendants and your third-party defendants regarding valuation. They don't have to agree with you. You don't have to agree with them. But relatively recently, I mediated with Jeff a wrongful death case, terrible case. Jeffrey and I were hoping to resolve it with a 3 in front of it. We had reported that to our carrier. There were a lot of
Issues.
other things going on in the case. The third-party defendants counsel, somebody very, very difficult to deal with, basically didn't want to talk to us, walks in and in front of the plaintiff and the mediator says, this case is going to have to resolve with a 4 in front of it. Well, the case resolved with a 4 in front of it. How shocking is that? When I say things are personal, many years ago, I mediated a case at JAMS before Judge Herkin-Torres. I was lead defense counsel, again, a wrongful death case. Herkin-Torres came out to me, the mediation was locked. He came out to me and he said, plaintiff's counsel has no use for your defense counsel, no use for the third-party defendant, doesn't particularly like me, but she really likes you. So can you go in and talk to her? I said, Judge, I'm paying you to mediate the case. Are you going to split the fee with me? You want me to mediate my own case. But that's the example of personal contacts, credibility. Nothing is as important in this business as your credibility with both your adversaries and your co-defendants, who are sometimes, in reality, bigger adversaries than the plaintiff. Line up your coverage and indemnification. Anthony mentioned this. This is so important. If you don't have your coverage issues lined up before you walk in the door, you are wasting your money. Okay? You're always going to argue percentage on negligence. That isn't a foregone conclusion, unless it's a 240 case. But even then, I'm going to turn around and I'm going to say, well, I'm statutorily liable, but I'm at the top of the sliding pond and you're at the bottom of the sliding pond. And let me know when you want $5,000. I firmly believe that mediation, while a summary judgment motion is pending, is the best time to mediate. I know, there's nothing that says you can't start before and you can't start after. When summary judgment motion is pending, both sides have the sword of Damocles hanging over their heads. Plaintiffs' lawyers don't want to lose summary judgment. They've laid out a lot of money and they want to be able to get their money back. It's a business. We're on both, as I said, we're on both sides of the coin. It's a business. We don't want to have to go to our carriers and say, oh, we lost summary judgment. Yeah, I know we said we had a 70% chance to win summary judgment, and then we blame it on the judge. Everybody blames things on the judge. By settling, while summary judgment is pending, you avoid the embarrassment on both sides.
Mark, can I interrupt for a second? I want to ask you a question. This is a practical question. Companies spend a lot of money paying for summary judgment motions. And companies come into it with the expectation that it might be dispositive. And I'm sure Anthony will be able to hear me out on this. But is there a bit of a frustration from the insurance company's perspective when you've spent all that money on a motion for summary judgment, and now while the summary judgment motion is pending, you're saying now's the time to resolve the case?
I will tell you that I have never run into that, because on the cases I handle and my firm handles, we give the carriers realistic evaluations of both liability and damages from the very beginning. Of course, it changes, facts change, plaintiffs get more surgeries. We roundtable every case in the office regularly, bill of particulars, depositions, a whole bunch of our trial lawyers team, senior counsel, and we discuss cases. That BP comes in, depositions, IMEs, investigation, so that we have a complete and honest picture. If I'm telling the carrier that I recommend that we make a summary judgment motion, the carrier knows why I feel that way. They know my feelings as to the possibility of success. They know I tell them whether we might have to go to the appellate division one way or another. You have to manage expectations. You have to give the carrier realistic evaluations. You have to provide plaintiffs' counsel with what you deem to be a realistic evaluation of their case. If it's somebody you know well and you can talk to, and we're a large industry and a very small fraternity or sorority or social club, I have to be politically correct now, you can speak honestly to your adversary, and they know their files. I'm not talking about the lawyer who has one negligence case in their office and does real estate and trusts and wills, etc. I'm talking the pros. Sachs and Sachs knows their case. They know their strengths and they know their weaknesses. Don't go in thinking that you're going to pull the wool over anybody's eyes. And they will go to a mediation without, if they respect you, without thinking that they're going to pull the wool over your eyes. But that's what Anthony said earlier. It might not resolve in one day. You have to keep going. You don't throw up your hands. You keep working it with the right mediators. Jeff and I had a case, and the mediator worked it and worked it. We worked it for over a week on a very heavy labor law case, and we got it done. There were a lot of, these are multi-party cases. They don't always fall into place at the same time. Very honestly, how many times have one of us gone to a mediation where the co-defendant who has $5 million worth of coverage and, you know, I don't know, hit the plaintiff, started the chain collision by hitting the fourth car in the rear end, and you have a paraplegic, God forbid, and they come in with $100,000. What I say is make sure that that's not, try to do your best to make sure that's not going to happen. I'll close by saying every carrier has a different philosophy on resolution. As defendants, we have to take this into account when we try to resolve the case. I've been admitted, I was admitted in 1979. So I'm 40 years old. And only once in, watch it, Miller, only once in my career have I had a carrier say to me, when I said we should go to mediation, what's the matter? Are you scared to try the case? My response was, no, I'm not scared to try the case. I will try any case, but you pay me to give you my recommendation. That insurance carrier is out of business. That is a business model that does not work in our industry. I'm doing it, Jeff Miller. In further conclusion, you have to be ready to try your case. If your adversary thinks that you're afraid to try a case, if they think you're afraid to take a verdict, then you will not get a reasonable demand, nor will they be reasonable at mediation. They have to say, well, Pillinger, Miller, Tarallo has tried, and Miller could actually tell you, X number of cases to verdict in 2022. And they know that we're going to take a verdict. Sometimes we win, sometimes we lose, sometimes we get burnt. But you have to have big people's pants, and you have to be willing to take a verdict, or you're never going to get a good result at mediation. That's the secret to a successful defendant's mediation, being prepared to try the case.
Excellent, Mark. I think you've got some very, very, very important insights. I like the one, and we've talked about this before in some of our prior conference webinars about communication. Jeff touched on it. You touched on it. Anthony touched on it. Communication is one of the ways that you get to the final result. If people can communicate, if people can be honest about what the case is about and where they see the case is going, you can always have a discussion. And we've talked about that, which is a great way of starting. So let me ask John Tambascia. John practices in New York and New Jersey. New Jersey practice is a little bit different than New York practice. And John has also mediated cases. He served as a mediator. So he's got a lot of good hands-on experience seeing from both sides of of the equation where mediation pans out. So I wanted to ask John to please give us secrets of mediators for successful mediation. John, can you tell us
Well,
about that?
The first thing to keep in mind is that failure to assess not only your adversary, but the forum you're in is going to destine you to failure. In New Jersey, we have three forms of mediation. One is you can get court-ordered mediation through a court-ordered mediator. You can have independent mediation, or you can have mediation through a special master, depending on the size of your case. Now, the latter two are easy. They're identical to New York, very well controlled, very managed. Court-ordered mediation is not as good in New Jersey as it is in New York. One of the key things to keep in mind is the talent of the bar in New York. This is not a slight on New Jersey attorneys, but in New York City, the 5 boroughs in particular, you have far more cases, far more experience, far more variety. People are operating at a higher speed. While New Jersey is a much faster practice, you still have a state with probably about as many attorneys in New Jersey as there are in New York City, spread out over a much larger area. And so you can really get stuck with people who don't understand that mediation is not free discovery. It is not a time to argue your case. It is a time for resolution. That doesn't mean roll over, but that's key. Because in New Jersey, one of the biggest problems is the plaintiff's bar, in some cases, will opt to take the discovery in the case. There's a track, and they will try to force the defendant into a corner. And it is a very successful practice. So you have to be able to push back. This is where Marc has said you have to be willing to try the case to make it work. As a mediator, my role is to first bring the parties together. I always in New Jersey will send an email and a letter that says, 1, you will bring number 1, someone with authority to the mediation. They can be on call. 2, you will bring an attorney who is familiar with both the file and the area of law. A lot of people don't get into that. It's very easy to have a first-year associate or a third-year associate show up on a case that's a construction injury case, and they know absolutely nothing. They've been doing auto for years. Really, the 3 months they've been practicing, and you're stuck. Another thing to keep in mind is hiding information in both contexts. This is just like putting on a show. People expect when you go to a Broadway show or to a rock concert, you're going to see certain things. No different in mediation. I always like to use Led Zeppelin as an example, but the point is that you knew when you went to one of those concerts what you were going to get. You didn't know what the show was going to be like exactly, but you knew what you were going to get. That's key for us. Now, at our office, we make sure that before we go to mediation, we disclose all the necessary proofs to prove our case, so that when the mediator is talking, and that could be me, to the adversary, I don't get, which I typically get when I deal with the plaintiffs, oh, you had a report. Oh, you had an IME. You had somebody do a polk analysis. For example, in New Jersey, you need a polk analysis, which talks about permanency, and it wasn't shared. How is the other side, who's already invested maybe $2,000 or $3,000 preparing for mediation, going to respond? So that has to be done. Another thing is the never-ending mediation statement. Some cases do require large statements, but when they don't, remember, you're paying for the mediator's time. You don't have to give a recitation about the standard for summary judgment. You don't have to give a detailed analysis of what a tort threshold is, or labor law 240 or 241, or the nuances. Just say, okay, under 240, this is our position. Here's a case. If you want to speed things up for the mediator, here's another idea. Give an index of cases, or have a table of contents, and at the end put the cases you're citing that are key. Another thing too, which is critical, and I think this is getting back to the first point, knowing your adversary. Remember in New York, you have the Supreme Court Appellate Division. Supreme Court, it's a trial court, unlike New Jersey. And one of the key things is this is where it comes to knowing your forum. If your adversary's tried a lot of cases similar to what he has, research him as well as the type of case, cross-reference. You'll find out what his high and low is. And I've done that on numerous occasions, especially with death cases. You have an individual who's in their 60s, horrible injury. How are you going to value that case? Well, if your adversary's been around, they're going to have tried it and gone to the appellate division. That will give you a set of values and scenarios. And so in your own statement, you can put down, we know he's hit for 500,000 at the low and $1 million at the high. You don't have to then worry about getting to know the attorney that you've never dealt with before. In New Jersey, it's a little different. You're going to have a harder time. You have to do a jury verdict analysis, and you'll also want to make sure you know your forum. Okay, that means the counties, they group differently. You'll have to talk to your own counsel about that, but Middlesex is feast or famine. Essex is generally more plaintiffs oriented on liability, but damages aren't. So those are nuances. Another thing is, and I think this is the biggest problem throughout every mediation I have attended or managed. Almost everyone wants to argue the case. My role as a mediator is not to preside as judge, jury, and executioner. My role is to preside as a mediator, to keep the parties on track and focused. So when I hear parties come in and say, we have a very strong liability case, all right, did you file a motion for summary judgment? That's my response to them. And when they tell me no, I'm like, well, okay, your case isn't as strong as you thought. And I said, that's also a good tool that you need to use. Now, I do not tell this in front of both parties, obviously. But, you know, summary judgment is a fantastic tool to get parties to come together. I don't think it's used enough. But when it's not filed and somebody tells me how wonderful their liability case is, that's not credible. And remember, the adversary who now has their client present is going to talk to me. I will not disclose what I talk to defense counsel about or plaintiff's counsel about, but especially now we're dealing with the plaintiff in this scenario. I have to give them some meat and potatoes as to what the weaknesses are. I'm not going to disclose your whole case, but one of the things they're going to tell me is, well, they didn't file summary judgment. And vice versa, I'll tell them the same thing. Focus on negotiation. So we can agree to disagree. We have different views on the case. That's probably the most mature thing to do. But then what I want to do is move forward to the actual negotiation. Some people call it horse trading. The real focus here is making sure that the parties get closer. Now, I'm not saying that getting close means if one party's at $1 million and the other's at 100,000, we split the middle. No, that's not getting close. All right. That would be, first off, you wouldn't need me as a mediator. You wouldn't need a judge and you wouldn't need a jury. Getting close is we have, for example, a case. We'll take a simple example. Cervical injuries, which we know are not related to the accident, but there may have been an aggravation. And we have, say, a knee tear needs surgery, clearly related. And we have a few minor back issues. I'm keeping it very simple because one of the things the plaintiffs will do is they want money for all of these aggravating injuries as well as the knee. Not realistic. And I have to tell them that. Then, you know, we can take a case. You'll see, for example, something about 1,000. You'll bring it down. And we can use brackets. I have no problem with brackets, but I don't recommend using brackets early on. The problem with using brackets early on is it tends to put people apart. Later on, it can be a very good tool. So even if you have brackets, say party A is at 300 to 400 and party B is at 7 to 850, all right? We can discuss why they're at those brackets, and I can use those aspects to bring the parties together. So for example, on the defense side, if we have an issue of the intransigence and okay, the aggravation of the back and the subsequent surgery is not related to this accident. Okay, we can demonstrate that there was an intervening event, a subsequent accident or something. I can work with that as the mediator to go to the plaintiff and say, listen, it's not a factor in this case. You're going to lose. I can tell them. I'll say, listen, you're not going to lose it at trial because of your talent. You're going to lose it at trial because of the facts. And I'll ask them, outside of the presence of their client, of course, why are you doing this? Right? And I'll learn something about the case. If the client is driving the case, then I will work with the client. I will sit down and I will explain things. And remember, I have to explain things in a manner that doesn't insult the attorney. And that gets back to the first thing. When you go to a mediation and people, especially plaintiffs' attorneys, love to pull the old, I'm walking out of here. Okay, they do that a lot, but they come back. It doesn't endear them to the claims professional and the client that the defendant's bringing. But more importantly, it builds unrealistic expectations up with their own client. And so we have to take steps to throttle that back. That gets back early on. And that's where I can be the most effective person. And where you, when you have a case, reach out to the mediator. If you believe there's a problem, and I think this is the number one thing with the client's perception of the case, be it the plaintiff or the defendant, it doesn't have to be your own client. Reach out to the mediator to explore that. You don't have to know everything about their life, but sometimes it does. And I'll just end with this story on a case I settled a couple of years ago in Richmond County. Very, very, very nice young woman. She was killed she ran out in the street, run over by the client in the car, truck, terrible accident. The mother sat through all the depositions and court appearances with a photo of her daughter. And I had to break the impasse, and I explained to her. I said, ma'am, I can relate to what you're talking to, and I have my own reasons explaining it. But the point is once we broke that impasse, that she thought no one cared about her feelings and her daughter, and we explained that that's not what's going on here today. The reason we're here today is because people do care. And nobody was being nasty to her. They were very respectful. We explained it. Case settled. And it settled not for what was being demanded. It settled for a realistic amount. So use the mediator. Even for a minor question, use them. You're paying for their time, and that's going to help dramatically. So I hope that helps a bit.
Thanks, John. That was very, very incisive, very, very helpful. How about we take a polling question now, and then we'll move on to a little round robin. Here's another one. I know they're not the hardest questions, but we try to make it so that everybody could answer them. We want 100% people answering so that we can get everybody the CE and CLE credits. I had a question that I wanted to ask the entire panel here and see how this can be used and resolved. We know that in a lot of these cases, there are going to be medical liens. You're going to have Medicare. You might have funding liens. All of these issues can complicate settlements. How important is it? Let me start with Jeff up top. How important is it to the resolution of the case to try and get a handle on this before you get into the mediation, as opposed to having somebody say, well, I just got this yesterday, but I'm not sure exactly what it's going to do or how it's going to impact the case. Jeff?
You're absolutely right, Tom. It's critical. Can't tell you how many times that we've been at mediations and somebody says, oh, by the way, there's a $345,000 funding lien. And it's not something that's our responsibility, but it's something that becomes an impediment to settlement. And the lien is similar. If there's a lien to be paid back that's not getting waived and you're not aware of it, and valuing the case one way, and you get into the mediation, and you find out about this tremendous lien, it is definitely going to be a problem. So the more information you have, knowledge is power. One of our attorneys and partners, Larry Buckman's at a dep today, and he knows it's an important dep with something going on this case. And he said, just 5 minutes ago to a bunch of us, oh, I did my usual before the dep. I spoke to them yesterday. I got all the updated lien information. I found out about any funding loans, and it's something that you do in advance. Get it done in advance, and it's important.
And we have a question from.
Can I just
someone.
make a comment
Yeah.
on that?
Sure.
When a defendant and the carrier goes to a mediation, they are basing their evaluation of the case on the information they have at hand. The insurance companies don't twist on a dime. Many times they need 30 days in advance of the mediation to get your mediation submission, your recommendations, because they have to run it through committees. This is our business. For a plaintiff to come into a mediation and tell you for the first time, we have a funding lien, or we just found out that the workers' comp lien that we told you was $60,000 is now $320,000, or worse still, and this is my bugaboo that kicks me off. They come into the mediation and say, oh, by the way, last month our client had a fusion or a discectomy or an arthroscopic procedure on the shoulder. And then they expect you to have come to the mediation with enough money to cover that fusion, assuming that it's causally related and was justified. They're wasting all our time. We're paying a mediator good money and we're throwing it down the drain. And unfortunately, this does happen, especially on funding loans.
We have a question, an excellent question. Question is from John McCune. It says, it seems every claim requires mediation these days. Whatever happened to picking up the phone and making an offer? How do claims professionals and/or defense attorneys get the attention of a plaintiff's attorney to discuss settlement without the time and cost of a mediation? Who would like to take that one?
There's no question, and that's a great point, John. The amount of that proactivity just isn't there. And I can't say why, other than, sorry for the younger people, some younger people laziness. They don't like being on the phone. You can settle cases without mediations, and you can settle cases early on without mediations, and you can get the attentions. You start calling somebody and you say you got money, and they're calling you back and they'll be on that phone. There are nil type practices that are very hard to get their attention early on because they don't know their files. They have too many files. They're not prepared, and they're just not ready to get pinned into a corner on a number because they're not ready to present the number. So those people that have those volume practices, and I'm not saying this in a bad way, now I'll mention some firms, the Melillo and Grossmans, the Harmon Linders, it's hard to get some traction with those people, but I mean, we have relationships, but those guys have such volume that it's hard to get something moving. But if you have a relationship and you know somebody in one of those offices, you could call and say, hey, look, we got a carrier that wants to move a case. Let's start moving it. We don't need a mediation.
So there are law plaintiffs firms, and we all know who they are, where the senior partner has to put a number on the case. And until the note of issue has been filed, the senior partner is not going to look at that case because he or she or they have too many other cases to look. I will give kudos to Jeff Miller as much as it hurts me, because of the relationships that he has established in this industry with the top players, with the plaintiffs' lawyers, and who this is all they do, and they have regular six-figure results. They'll always take Jeff's call, and they will always tell him either here's a demand or here's why I can't give you a demand now and I can't go to mediation. I have had carriers, because nobody who we represent, of course, where the adjuster wants the mediator to put a number on the file so that they cover themselves with their supervisors. And I'll punt this to Anthony, because I know that Anthony's the guy who can put the number on the file. So, but especially when you have young kids on the desk, they're terrified to put a number on, and they want to be able to go to their supervisor and say, well, the mediator said $300,000 and PMT said $300,000. So I guess we should put up $300,000. They want the good housekeeping seal of approval. Have you run into that, Anthony, in your career?
Sure. Yeah. I mean, I haven't seen too much of that. I mean, obviously, I've seen adjusters that have certainly punted the file and not wanted to be involved in it, and kind of left it for a supervisor or a manager to touch on. So I've certainly seen adjusters that punt. But on the flip side of that, I've also had cases to kind of piggyback on McCune's point, where you'll call up a plaintiff attorney, you'll try to talk to him, and he won't be able to resolve the case because his client doesn't have a realistic number of what they want. So he really wants to have a third party that can kind of chime in and help push the case along, because he doesn't want to be the one to give the impression that he's capitulating with the insurance company. So he'll want to have a mediator actually do his dirty work of resolving a case at a number that it should be resolved at.
Many years ago, I had a case where the plaintiff's counsel and I agreed on the settlement number. It was very fair. He couldn't convince his client, so we went to mediation, and the mediator convinced the client that this was a fair settlement value and she should take it. And she didn't believe her lawyer, and she didn't believe me, but she believed the mediator, because the mediator was a former judge and she had respect for the judicial process. So I know where you're coming from. And sometimes you do need that third party.
We have a question here, a comment from Carolyn Solo, and talking about how to get people to the table to discuss cases. She says, I try inviting claimant/plaintiff counsel for a cup of coffee and a cookie and a conversation at an attorney's office, so there is a legal backup / someone to consult with on issues out of my wheelhouse. Again, pointing to the obvious way that if you can get people talking, start a discussion and a conversation, it's easier to get cases resolved. Have you found this to be true, John?
Generally speaking, yes. The key is you have to throw money out. You have to engage. Unfortunately, the plaintiff's bar, you have to understand, in New York, you've got 9% interest. In New Jersey, what they're doing, and this is something people don't understand, the plaintiff's bar has control of some of the county bar associations. They work with the bench to cherry pick cases and get good cases in to make the numbers inflated. So you really have to reach out on a more aggressive scale.
Great. And Anthony, you find it helpful to have more communication with the claimants attorneys as early and often as you can. That's another way of breaking down the barriers and getting people ready to finally come to the idea that the case has to be resolved. Right?
Absolutely. I mean, the more communication, the better. Obviously, your history with that firm comes into play. You know, the more opportunities that you can get in front of a plaintiff's attorney and give him an opportunity to know that you're a serious bidder, and that when you call, you're given a call because, listen, you evaluated a case, you've evaluated it properly, and you're looking to negotiate in earnest. So any opportunity you get, whether it's at, Jeff's NCAA party where you can shake someone's hand and let them know that you're, a serious participant in the process, are all good things. So the more you can talk to people, the more they can recognize your name and know that you are serious about what you say and you're a serious bidder is all good opportunities to be able to pick up a phone and be able to resolve a case when you can.
So we invite both plaintiffs' counsel, those who we deal with regularly, to our NCAA, to our rooftop parties. Every year we run a golf event for charity. So the adjuster is there and the plaintiffs' counsel is there, and you would be amazed how many cases get settled over a beer and a basketball game. Because again, it ain't business, it's personal. It's a different atmosphere, a different approach.
Got a very interesting question here, which I think will highlight some of the differences between New York practice and practice in New Jersey. Question is from Seth Kagan, and he writes, I've had defense counsel push back on my request for an early offer of judgment within the defense budget. Is there a reason why defense counsel would be hesitant to make an early offer of judgment? Who would like to take that question first?
Talk to it. Go ahead, John.
I'll just talk about New Jersey. Jeff, you talk about New York. In New Jersey, you don't make an offer of judgment without sufficient facts, because what happens is the way the offer of judgment rule is in New Jersey, I'll tell you this, it favors plaintiffs. So you may think you're doing yourself a favor on a case, but you're not. You're shooting yourself in the foot, as they say, because if you come in at a certain number, you don't hit the offer of judgment, and you're never going to get all the counsel fees and costs that you think you will based on the rule. If you want to know more about why it doesn't work, call me up and we'll have a cup of coffee and I'll do a seminar at your office. But that's why it isn't a short answer for New Jersey.
And I'm just going to throw out there, in New York, and I love the idea of offer of judgment. I just wish it had some teeth. Because in New York, and I want to get this right, but I'm close enough that I could speak to this, that when you make the offer of judgment, and if it comes in under that, they're only responsible for costs. But when they say costs, it's not defense costs. It's the transactional costs of an index number, a deposition transcript. So there's very little bite to it, because you're not getting back your defense costs with it, and it should be more punitive. And I wish that defense costs were included, because his business would be a lot different.
Do you think people get somewhat?
Hey, just Tom, if I can just make just one quick comment on what he said.
Please.
I think his overarching point is, if you're in the claim department and a claim hits your desk and you look at it and you're like, we're dead on liability, we're dead on damages, what are we doing, where are we going? It's just an opportunity to kind of think outside the box and be creative. Perhaps the offer of judgment isn't the way to go, but I think that the thought process is, if we know we're losing on day one, we might as well take steps, use techniques, think about things that can certainly drive that resolution, because as Miller mentioned earlier, this whole thing is a combination of, expense and indemnity dollars. So if you're going to spend indemnity dollars, why spend a bunch of expense dollars?
True, and I meant to say, what I didn't end with was that in federal court, it is different. In federal court, you get real cost on these cases versus the state court.
So it's a little bit illusory when people look at the offer of judgment in New York and say, oh, we'll get costs, make an offer of judgment. And then it turns out later on that they realize that all they're going to get is a filing fee, transcript fee and things of that sort. And all of a sudden, like Jeff says, it really has no punch to it. Is there any other way to make that have some punch? Or is it just something that can never be used in New York because of the way it's structured at present?
Say on a very small case, it could have some punch because the numbers are much lower. And then you have some, little bit of bite to it. Or a federal court. Other than that, they got to change the statute.
Well, let me ask another question. We'll move into another topic, which may be of interest. Anybody see or anybody think that the legislature will become more conservative and less progressive now that they've had a battle with Governor Hochul on her chief judge nominee, and now that she's vetoed the Grieving Families Act? You see this as being just set up for a more, mano a mano between a progressive legislature and a moderate governor? Mark?
I am on the board of the New York State Association of Trial Lawyers, over 5,000 members, the vast majority of which are plaintiffs. I am like the secret spy on the board because I'm a defendant, and I get to hear the lobbyists for the plaintiffs presenting what is going on in Albany. The Democrats have a supermajority in the Assembly and the Senate. They are extraordinarily progressive and I don't want to get into politics because Miller always yells at me. They are, for the most part, very much younger. Many of them have no business acumen or experience. They've come up through the nonprofit, not-for-profit areas or through government jobs, etc. You are not going to get favorable defense legislation through, probably not in our lifetimes. And, we got young people like Anthony on the panel. Be lucky if it doesn't go the other way. The governor pocket vetoed this. She offered several compromises to the plaintiffs' bar. One of which was shortening. So the proposal had to amend the statute, made it a 3.5-year statute of limitations, which is longer than the negligence statute. She wanted 3. They would have given her that. There was basically no discussions on the truly substantive matters because, in my opinion, neither side had much give. The real question is going to be, is the Senate and the Assembly going to try to override her veto? This was first time that a nominee by the governor for the Court of Appeals got turned down. I thought that the nominee was highly qualified. I've had the pleasure of appearing in front of the judge. He ran into political issues having nothing to do with judicial temperament. Again, this is all my opinion, not the opinion of PMT, not the opinion of Jeff Miller, not the opinion of the New York State Trial Association of Trial Lawyers, not the opinion of my wife and children. I think this is going to be a difficult time for the defense bar. I was cautiously optimistic that when it came to labor law and 240 cases, that we were getting what I would deem to be a more rational approach to labor law accidents from recent Court of Appeals decisions. I believe that's going to go by way of the wind. I believe the Court of Appeals will become more like the First Department. I'm probably talking too much. So until the defense industry, the insurance industry, the real estate industry, the construction industry learns how to lobby, and I don't mean the last minute, but I mean constant presence to the same level as the plaintiff's bar, we're going to have difficulty. And at the end of the day, the electorate now is much younger and much more progressive. So they're going to vote in candidates who reflect their points of view. And I get it. And elections have consequences.
Thanks, Mark. That was very, very incisive, and we really appreciate your insight, especially from being on the inside and hearing what our plaintiffs' brethren have to say about all this.
And I'm going to get a lot of calls from a lot of people saying, why did you say that? But
that's okay. That's what we want. We want to have an open, honest discussion about interesting and incisive topics. So let's put up our last polling question, and then we can call it a day.
you really want to ask that question?
Sure. We've asked it because we think that we're providing real value here. As I always say, results in value with swift resolution of cases. We like to serve as an information resource for everybody. So if you have questions, whether it relates to a case or not, please feel free to contact us. You can contact Marc, you can contact Jeff, John Tambascia, myself. We'll be happy to do that. If you'd like a webinar on a topic, happy to provide that to you because we're here to serve as a partner with you, to work with you. I do want to thank everybody for attending our second PMT Claims Settlement Institute. We've had a great discussion. I want to thank Jeff Miller, Marc Pillinger, Anthony Coleman, who we drafted late in the process, who stepped in for one of our panelists who could not make it. And I want to thank him very, very much for being
Superstar.
once again. Yep. And John Tambascia also for being on our panel. We've had a great discussion. And I thank you guys for all coming. And I want to thank St. John's. I want to thank Joe Levine and Rob Stewart from CC&G. So thanks everybody for coming. Very happy and pleased to serve as your moderator, and we hope to see you soon. Wait, we have one more question. Let's see. Is there one more question up here? Oh, there it is. Oh, okay. Carolyn Solo said, thank you all. Great presentation. Thank you, Carolyn. Glad that you could attend. And like I say to everybody, if you have questions, please feel free to contact us. We're here to serve you. So on that note, I want to thank everybody. Have a nice weekend coming up. Super Bowl, whether you're rooting for the Kansas City Chiefs or the Philadelphia Eagles. We're not going to go into that because that's almost like talking politics or religion, which we want to try and stay away from because, you know, we don't want to inflame people. But let's hope it's a good game and somebody wins some of the boxes that we've all participated in. That will make it a lot more fun. So thanks, everybody. Have a great week, and thank you for attending our
Thank you.
PMT CSI webinar.
Thank you very much.
Thank you very much.